with the house. And this is, again, a big part of the estate planning equation and a big asset for most people. And there's a practical challenge to try to figure out how to split this up as well. So we're going to try to unravel some of the complexities and help you gain some insights into effectively managing your real estate within the estate planning. And Ted, this is probably a pretty big one for everybody you work with, right? I mean, I feel like in generally speaking, this is going to be the biggest asset most people have, right?
Oh, without question. The first thing people come in to talk about is what's going to happen with the house when they're gone, and that's for the most part, when someone starts working, that's their first goal is to buy that house, and hopefully live in it as long as they can. And so the house is by far the most valuable asset, the most important asset, and the one that generally involves the most complications in terms of getting it to beneficiaries.
Exactly. And, once that family decides, the basics of their inheritance plan, who's going to receive what, they got to figure out, how much they are leaving each beneficiary. And of course, as we mentioned, the house is difficult to split up. And, if you've owned a property or multiple properties, you know what it's like having co-owners as well. It can be a little bit difficult there as well. So I want to walk through some different scenarios with you, Ted, and how you'd handle it. So let's start with the one where maybe it's the easiest. All beneficiaries that you have are adults. They're all self-sufficient. They do not live at home. So you have this house that they don't necessarily need to utilize, but how do you think about passing this along?
Yeah, and this is generally the more common scenario, especially when you have self-sufficient children who've moved on. They've got their own lives, their own families, and everybody's kind of left the nest, so to speak, right? So in that scenario, usually the best way to handle it is to just treat the asset as or the house as any other asset. You include it as part of what we call the residuary, and you just divide it in the same manner or a similar manner as you would every other asset. And that generally is the more preferred way. But there are circumstances where family members may specifically want that particular asset, or a little bit more specific. So maybe you provide a specific designation and you specify which of your children, or any combination of children or other beneficiaries would get the house, or the value of the house when it's sold.
So you kind of have the option to either make it really specific about how and who has the option to take it versus just, hey, I'm leaving it to you, and it's kind of your deal tackle moving forward on and what you want to do with it. Do you want to sell it? Do you want to try to utilize it, rent it, whatever it is? I'm just going to leave it open ended for you.
Right. And usually what happens, when you have self-sufficient children who've already moved on, the more preferred and more likely scenario is going to be that division in percentages. And basically, as part of your estate plan, upon your demise, it would essentially, the asset would be sold, or the house would be sold, and the proceeds would be divided in the same manner, or become part of the general estate and be divided in the same manner as you prescribe in either your will or your trust, or other documents. So that's generally the way that would be treated. Now, you could have a scenario where you specifically designate one particular child as receiving the asset, the house. But in that scenario, it could also be the same, a similar type of thing where one child is receiving, or one beneficiary is receiving the house, but that doesn't necessarily mean that child is required to reside in the house. It could just mean that the proceeds of that particular sale of that house could be used to pay off that person's distributive share, as part of their estate plan.
Gotcha. And then for this scenario too, is it common for people to have the discussion with their children and just loop them in early on before deciding this? Or do you find that a lot of people just say, hey, this is kind of what I want, and we'll just make the kids deal with it?
I think so. Like with every estate plan, it kind of depends. So certainly, there may be emotional attachments that people have to homes. You may have a circumstance where, while one beneficiary is, while all the beneficiaries may be self-sufficient and have their own families and their own circumstances, they may actually want to go back to the family home, or they may want to actually do that. So having a conversation certainly can alleviate a lot of these questions and a lot of these concerns about how to deal with that particular that particular issue. And then you can have scenarios in which if your intention is that you want to divide the asset equally or the value of the asset equally, but you want one particular person to have a priority as to residing it or something like that, then you can be specific and provide guidelines as to how that can happen as well. So so communication is a very important part of this discussion, as with every estate plan. As we've mentioned before, it's probably the preferred way to do an estate plan.
Yeah, communication always key. And if you want to communicate with Ted and his team, again, you can always do so by calling 718-233-2903 or log on to lasseslawfirm.com. All right, that was the most maybe common scenario. This one less common, but maybe Ted becoming more common as more and more adults are living with their parents due to finding jobs or whatever the reason might be. But what if you have one or more adult beneficiaries living at home? Then what kind of arrangement do you set up?
Right. So now this is a scenario that's becoming more and more common, as you mentioned. The sandwich generation is the generation that's that's younger than the parents who are planning, but older than their kids, and they're kind of caught betwixt and between, and they're kind of taking care of their parents and taking care of their kids at the same time. And a lot of times when you have that, and that's done by someone who's living in the home with the parents, and the parents own this home, and in order to feel that they're compensating or taking care of that person who's taking care of them, they may want to provide for the house to be part of that person's legacy. So that is a very common scenario. And so in a scenario like that, you'd want to be very specific as to what's going to happen upon your demise. And then if you feel that there is a need to compensate another beneficiary because you feel that it may not be equal or it may not be fair, then to provide some sort of scenario where the person who's residing in the home perhaps compensates the other party or the other beneficiary with either a buyout or some sort of other asset swapping, fair market value, or maybe some sort of specific criteria. So there are a lot of different scenarios that can play into what happens in that. But that again, we go back to that, communication. That's a very important part in a scenario like that.
Yeah, I feel like the communication even more important here, maybe than the previous scenario, although it's still important. Do you often see a lot of disputes in this kind of arrangement as you're trying to sort things out?
Yeah. So I think that when you have when you're not clear, then it does result almost invariably in some form of a dispute or another. I think the most frequent scenario in which there's a contest or a challenge to a will, it's in this scenario where one beneficiary perhaps got a little bit of a leg up with regards to the house, and so the one who's not getting the house is feeling left out or doesn't feel that they were adequately taken care of because one person got the most valuable asset. So this is where communication is certainly preferable, and it goes a long way to avoiding some of those conflicts, and being very specific in your plan also is important. Probably the most important in a scenario like this, and also one of those scenarios where a trust is preferable to a will, so that you can avoid some of these contests as well. So lots of different things go into the analysis on a scenario like this, but communicate. It starts with communication for sure.
All right, so let's move on to another one that hopefully you don't find yourself in this position. But what happens if all your beneficiaries are underage? What are some of the questions that you have to sort through?
Well, okay, so someone who's underage can't own real property, right? So if the intention is that that person's going to be the beneficiary of the estate, then you have to find out. You have to determine who's going to take care of that child, right? What sources of income are going to be used, or what sources of money or cash are going to be used to maintain the home, and then are the guardians already living with the child? Are they going to live with the child? What are the benefits of the children remaining in the house versus selling the home, liquidating the asset, and reducing it to cash, and perhaps using that cash as a means of funding a life for that individual child. So there are a lot of components that go into the discussion when it comes to trying to figure out how to best deal with a scenario where a minor is going to be the beneficiary of a home.
Okay. It is can be a tricky situation as well. Does it matter how old they are, Ted? Is it
Well,
easier for 16 or 17 versus 4 or 5?
yeah. So yeah, of course, I think the closer they are to reaching, the age of majority, it's less of a concern financially, obviously, but then we have other concerns to deal with as well, right? So you have to worry about things like, being eligible for financial aid for college and things of that nature, also. So there are the age of the beneficiary creates a different problem at a different stage in their life. So it's important to kind of think about the consequences of that type of a decision where you're providing for a home for that individual child or children who are minors. So you really kind of have to think it through, while you're going through your planning to discuss it, and that really goes for all the scenarios that we discussed. How do you maintain the home? If a beneficiary is going to be getting, is going to be receiving the home, can they afford the home? Can they maintain it? What types of restrictions are you planning on putting on sale, for example? Those are all things that need to be thought about when you're talking about giving someone a home as part of your legacy.
All right. What about a couple of special considerations for the house I want to throw at you before we finish up this episode? And you've kind of touched on these a little bit, but just kind of pointing these out. These are some things that could happen when you are thinking through how to pass your home along. But what if someone lives there? They need to live there. They depend on living there, and they're not in a position where they can easily support themselves if they have to move elsewhere. Is that a difficult thing to work around?
So it can be, certainly, when you're planning for a scenario like that, you have to think about, what financial resources are going to be available to that individual to maintain the home and who's going to be doing it for them, right? Because if they're unable to support themselves, or, maybe they're, physically disabled, or they've got some sort of impediment to being able to manage affairs on their own, then, how do you ensure that that person is taken care of, and what is the best scenario to do that? Certainly, a lot of things will go into that consideration. For example, is the mortgage on the house paid off, for example? And what does it cost to maintain the home on a regular basis? What type of income is coming into the home? Is the home income producing on its own? Lots of those scenarios. And is the person who's living in the home by themselves, are they a danger to themselves or others? And what possible risks are there if that person is expected to live alone? So a lot of things have to go into thinking about that type of scenario, and detail and paying attention to that before you make your plan is important.
Yeah, I know you mentioned some sentimental, emotional attachment that happens, comes with the home. You got to think about, I guess you got to think about moving to a different area, or if there's a school district, if you have minor children, thinking about that with the house as well. Then what about a transition period? If somebody's got to move out of the house versus having to evict them. Is there some flexibility there?
Yeah, so that's a similar, so that's a complication of a different sort. So, oftentimes we have a scenario where the house needs to be sold, and because that's the only asset, and it has to be divided a certain percentage. And the only way to effectuate that is to list the house for sale, but you can't list the house for sale because someone's living in it, and one of the people who are living in it is one of the beneficiaries. And that can certainly tie up the estate, and certainly tie up all the other beneficiaries. So, you can run into scenarios where, it puts beneficiaries at loggerheads with each other, where they're basically in court constantly trying to, fight over the estate until it's sold or liquidated. And that can affect the value of the estate for the other beneficiaries. So that's a concern as well. And, frankly, an eviction's eviction. So it's complicated. For, it's complicated even when there aren't estate concerns. It gets even more complicated when it's an estate issue, because first the fiduciary or the executor has to be appointed, and then once the executor is appointed, then that person can bring a proceeding, and it gets complicated. So it can be a scenario that could cause a lot of delays in an estate, in the estate administration. It can cause value to be lost because of the difficulty in trying to liquidate property with someone in it, or waiting for someone to be evicted. Here in New York, it takes a long time to evict someone. So and that's under normal circumstances. So it is a consideration, something that thinking about in advance is an important thing to do.
All right. Well, if you haven't started thinking about what you're going to do with your house, or maybe you have a complicated scenario you want to work through, or just have questions that you want to ask Ted and his team of the Alatis Law Firm, you can always do so by logging on alatislawfirm.com, or you can call 718-233-2903. There's a lot of great tools on the site, videos, our podcasts, or some DIY estate planning information there as well. If that's kind of an avenue you might want to explore, but also want to have the help of someone like Ted who does this every single day, that option is available to you as well. But of course, the best thing to do is just to start that planning process now. So 718-233-2903, best way to do that. Ted, as always, thanks for your time. We'll do it again soon.
Absolutely, Ben. Great to talk to you.
All right. Perfect.